You don't walk past the police van, you walk through it. Since the 22nd of June 2026, Western Australia Police have been running marked vans fitted with live facial recognition cameras at locations around Perth. It's the first deployment of its kind by any police force in Australia. In the trial's first 5 weeks, the system scanned more than 131,000 faces, generated 33 alerts, and contributed to 19 arrests. All of that happened before the state's new privacy law had fully come into force, and without the independent regulator responsible for exactly this kind of program being consulted on how the trial was designed. Let's start with what this technology actually does, because the comparison to ordinary CCTV that police keep reaching for doesn't hold up. A standard security camera passively records footage. What happens with that footage afterward is a separate decision, usually made by a person, usually after the fact. Live facial recognition is structurally different. Every single face that enters the camera's field of view is actively identified in real time. The system detects and segments each face from the background, normalizes it for lighting and head angle, measures the geometric relationships between facial landmarks, eye spacing, nose width, jawline shape, and turns all of that into a mathematical biometric template. That template is then compared instantly against roughly 4,000 entries on a police watch list, outstanding warrants, registered sex offenders, missing persons. Now, the number that actually matters. West Australian police and government officials have repeatedly pointed to the scale of the trial: over 131,000 faces scanned, just 2 confirmed false alerts, as evidence that the system is precise. That framing technically isn't wrong, but it's not the useful number either. The system only generated 33 alerts in total. Of those 33, 2 were false. That's a false alert rate of roughly 6% among the alerts that actually sent an officer to engage someone. Put another way, for roughly every 15 or 16 times the system incorrectly flagged someone, it wrongly sent police toward an innocent person. That is a meaningfully different picture from practically no errors in 131,000 scans. Here's where it gets more uncomfortable. Western Australia's Privacy and Responsible Information Sharing Act, the state's first law to directly govern automated decision-making, had its core information privacy principles take effect on the 1st of July 2026. The facial recognition trial began on the 22nd of June. That's 9 days where the trial was running under essentially no dedicated regulatory framework. And it gets worse. The state's own Office of the Information Commissioner has confirmed, in a formal statement, that it was not invited to participate in any consultation process on the trial's design. WA Police haven't publicly disclosed the specific confidence threshold they're operating at, which makes independent verification of any of this basically impossible. Zoom out, and the regulatory comparison is stark. Under the EUAI Act, real-time remote biometric identification by law enforcement in public spaces is banned outright, with narrow exceptions that require judicial authorization. Australia has no comparable national framework. The PRIS Act fills part of that gap for Western Australia's public sector specifically, but it contains no outright prohibition and no requirement for a judge to sign off before a trial like this one runs. And because this is the first Australian jurisdiction to deploy anything like it, whatever standard gets set here, strong or weak, is likely to become the template every other state looks to. WA Police have pointed to real safeguards that are absent from some overseas deployments. The van is clearly marked, signage announces each deployment, faces that don't trigger an alert are pixelated and deleted immediately, and an officer must independently verify a match before taking any action. Those are meaningful design choices, but they don't resolve the more basic question the state's own privacy regulator keeps raising. A sign is not consent. There is no way to opt out and still walk down that street. The trial is a 5-month pilot, with no stated commitment to a permanent rollout. What happens after it ends may depend less on the operational results than on the precedent already being set. A subject worth watching closely, as we do at Cyber Ethos.